Before we begin, a quick and important disclaimer. The information presented in this video is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. The legal industry and divorce laws are subject to frequent changes and vary significantly by jurisdiction. This content explores historical trends and statistical data from the 1990s and should not be used as a basis for making personal legal decisions. We strongly advise all viewers to conduct their own due diligence and consult with a licensed professional regarding their specific circumstances before taking any action. In 1990, the United States reached a staggering milestone that forever changed the landscape of the American legal system. While the cultural zeitgeist was focused on the rise of the Internet and the end of the Cold War, a much more intimate revolution was taking place in the boardrooms and courtrooms of every major city. By the early 90s, the United States had the highest divorce rate in the industrialized world, with nearly 1.2 million divorces occurring annually. This was not just a social crisis. It was the catalyst for the birth of a multi-billion-dollar industrial complex. We are talking about a decade where the average cost of a contested divorce skyrocketed by over 60%, transforming family law from a quiet, backwater practice into a high-stakes, high-margin corporate machine. During these 10 years, the divorce lawyer became more than just a legal representative. They became a forensic accountant, a psychological strategist, and a brand manager. If you want to understand why the modern legal system operates the way it does today, you have to look at the 1990s, a decade defined by the professionalization of conflict and the commodification of the American household. By watching this deep dive, you will gain an unprecedented understanding of how the 1990s shaped the economic realities of domestic litigation that still affect families today. We are going to peel back the curtain on the historical trends that moved divorce from a simple filing process to a complex financial extraction. For the modern viewer, this provides the essential context needed to navigate the current legal landscape. You will learn how the shift in asset valuation, the rise of the dual-income household, and the emergence of early digital forensic accounting created the blueprint for today's high-stakes litigation. This is a masterclass in the business of legal dissolution, providing you with the historical perspective to identify the pitfalls and systemic structures that define the family law industry in the 21st century. To understand the 1990s, we must first look at the sheer volume of the legal labor force. In 1990, there were approximately 780,000 licensed attorneys in the United States. By the time the clock struck midnight on December 31, 1999, that number had surged to over 1 million. This explosive growth was not evenly distributed across all fields of law. While corporate law and intellectual property saw significant gains due to the tech boom, family law experienced a specialized professionalization. In the 1970s and 80s, many divorces were handled by general practitioners, lawyers who wrote wills on Monday and handled a divorce on Tuesday. However, the 1990s saw the rise of the boutique family law firm. These firms realized that the complexity of assets in the 90s required a level of specialization that the general practitioner could no longer provide. Consider the economic climate of the mid-90s. We were in the midst of one of the longest bull markets in history. This created a new problem for divorce lawyers: the valuation of intangible assets. Before this decade, a divorce settlement usually involved the house, the car, and perhaps a pension. But by 1995, lawyers were suddenly dealing with stock options for 401k plans and early-stage equity in technology companies. This shift necessitated a change in how lawyers billed their time and how they marketed their services. The billable hour, which had been a standard for decades, began to climb aggressively. In major metropolitan hubs like New York, Los Angeles, and Chicago, a top-tier divorce attorney's hourly rate moved from an average of $200 in 1990 to well over $450 by 1999. When you adjust these figures for inflation, the cost of accessing high-level legal representation became a barrier that fundamentally altered the demographic of who could afford to litigate. The data from the Bureau of Labor Statistics during this period shows a fascinating correlation between the rise in female labor force participation and the revenue growth of the divorce industry. As more women entered high-earning professional roles throughout the 90s, the math of divorce changed. Alimony, once a relatively straightforward calculation based on a single-earner household, became a complex battleground of lifestyle maintenance and rehabilitative support. Lawyers began employing vocational experts to testify about a spouse's future earning capacity. This added another layer of cost to the process. It wasn't just the lawyer getting paid. It was the expert witness. By 1997, It was estimated that for every dollar spent on a lawyer in a high-net-worth divorce, an additional 30 to 40 cents was spent on third-party consultants, including private investigators and forensic accountants. One of the most significant historical trends of the 1990s was the implementation of the 1997 Taxpayer Relief Act. While primarily viewed as a broader economic policy, its impact on the divorce lawyer industry was profound. It changed the rules regarding capital gains on the sale of a principal residence. Before this, many divorcing couples were forced into complex legal maneuvers to avoid massive tax hits when selling the family home. The new law allowed for an exclusion of up to $250,000 in gain for a single person, or $500,000 for a married couple. Divorce lawyers in the late 90s suddenly had a new tool and a new complication in their negotiation arsenal. They had to become tax strategists overnight, further justifying the increase in their specialized fees. We must also look at the role of the American Academy of Matrimonial Lawyers, AAML. During the 1990s, the AAML became a powerhouse in setting the standards for what constituted a top divorce lawyer. This decade saw a massive push for certification and super lawyer designations. The psychology here was brilliant from a marketing perspective. By creating an elite tier of recognized specialists, the industry was able to segment the market. You had the standard divorce for the middle class, and the white glove service for the emerging millionaire class of the dot-com era. This segmentation allowed for the total revenue of the family law sector to reach an estimated $10 to $12 billion annually by the end of the decade. Step back and look at the cultural impact of high-profile cases during this era. While the O.J. Simpson trial was a criminal case, it revolutionized how the American public viewed legal teams. It popularized the idea of the dream team. Divorce lawyers took note. In the mid to late 90s, we saw the emergence of the multidisciplinary legal team in family law. A lead litigator would be supported by a junior associate for research, a paralegal for document management, and an outside firm for asset tracing. This team-based approach, while effective, meant that a single hour of casework could involve 4 different people billing at different rates simultaneously. By 1998, the industry also began to grapple with the pro-se movement, individuals representing themselves because they were priced out of the market. Statistics from various state courts showed that in some jurisdictions, up to 50% of domestic relations cases involved at least one unrepresented party. This created a dual-track system, a high-end, high-cost litigation machine for those with assets, and a struggling, overburdened public system for everyone else. The divorce lawyer industry responded not by lowering prices, but by further complicating the legal requirements, making it increasingly difficult for a layperson to navigate the system without professional help. This historical tension between the business of law and the access to justice is a theme that crystallized in the 90s and continues to haunt the legal system today. This decade didn't just see more divorces. It saw the birth of a sophisticated, self-sustaining industry that thrives on the complexity it helped create. To grasp the sheer scale of the revenue generated in the 1990s, you have to understand the mechanics of the discovery phase as it existed before the digital revolution. In the early 90s, discovery was a physical, paper-intensive form of warfare. Imagine a legal team in 1994, representing a high-net-worth individual in a city like New York or Miami. They were not just sending emails or sharing cloud folders. They were issuing subpoenas for thousands of pages of physical bank records, credit card statements, and tax returns from the previous decade. This process created a massive logistical requirement that the industry was more than happy to monetize. The billable hour became the primary engine of growth for family law firms during this era. Law firms started implementing strict quotas for associates, often requiring 2,000 to 2,400 billable hours per year. This meant a single complex divorce case could sustain an entire team of junior lawyers and paralegals for months on end. For instance, in a 1996 historical case study of a mid-sized firm in Chicago, we see a single contested divorce generating over $300,000 in fees before the parties even reached a courtroom. This was driven by a culture of motion practice, filing endless procedural motions to delay or pressure the opposing side. Every motion required a draft, a review, a response, and a hearing, and every minute was tracked in 6-minute increments. The 1990s were also the decade when the forensic accountant became the divorce lawyer's most essential collaborator. As executive compensation packages became more complex throughout the decade, with the introduction of deferred compensation, restricted stock units, and offshore accounts, the math became too difficult for a standard attorney to handle. These specialists would charge between $300 and $500 an hour to trace assets through a maze of paper. They would look for lifestyle discrepancies. Imagine if a spouse claimed they only made $100,000 a year, but the family's monthly credit card bills and mortgage payments suggested they were spending $200,000. The forensic accountant's job was to find the hidden income or the diverted assets. By 1995, the use of forensic accounting in divorce cases with assets over $1 million had increased by an estimated 40% compared to the previous decade. Let us look at a representative case study from 1995 to see how these historical trends functioned in practice. We will look at a hypothetical couple, the Thompsons. Mark was a vice president at a growing telecommunications firm with substantial but unvested stock options. Sarah was a stay-at-home parent who had supported Mark through his MBA and early career moves. In 1980, a divorce like theirs might have been settled relatively quickly with a focus on tangible assets like the home and a small savings account. But by 1995, with the widespread adoption of the enhanced earning capacity theory in several U.S. states, the legal battle shifted. Lawyers argued that Mark's MBA and his future career trajectory were marital assets that Sarah had a direct claim to because of her domestic contributions. This required expert testimony from economists to calculate the present value of a degree over a 30-year career. If a doctor or executive was expected to earn $5 million more over their lifetime because of that degree, the non-student spouse could be awarded a significant percentage of that future value. This required incredibly complex statistical modeling and generated tens of thousands of dollars in billable hours for both the lawyers and the actuarial experts. The final bill for the lawyers in the Thompson case could easily exceed $250,000. This reflects the historical trend of turning intangible potential into a quantifiable, lightangible asset. In the context of 2026, where artificial intelligence can scan 1 million documents for keywords in seconds, the 1990s look like a slow-motion goldmine for law firms. In 1997, a law firm would have a room full of paralegals earning $20 an hour while the firm billed their time out to the client at $75 or $100. They were looking for the smoking gun in boxes of disorganized receipts. This was the golden age of the billable administrative task. Firms would charge for every photocopy, often at 25 cents a page, and every long-distance phone call or fax sent. These disbursements or out-of-pocket expenses could add 10 to 15% to the total legal bill, purely as a secondary revenue stream for the firm. The step-by-step process of a 1994 paper discovery went like this. Step 1 was the request for production, where a lawyer sends a list of perhaps 100 specific items. Step 2 was the box delivery, where the opposing side would deliberately send 50 boxes of disorganized papers to overwhelm the other team. Step 3 was the document review, where junior associates would spend 12 hours a day in a windowless room coding these documents. Step 4 was the deficiency letter, where the lawyer would claim items were missing or illegible. Step 5 was the motion to compel, going back to court to argue about the missing papers. Each of these steps was a major revenue event. Furthermore, the 1992 Child Support Recovery Act added another layer to the industry. This federal law made it a crime to willfully fail to pay child support for a child living in another state. While intended as a social safety net, it effectively turned the private divorce lawyer industry into a quasi-enforcement arm of the state. Lawyers could now charge clients to initiate interstate enforcement actions, adding another category of specialized litigation to their practice areas. Statistical data from the mid-90s shows that the number of interstate child support cases handled by private attorneys grew by nearly 25% between 1993 and 1998. We must also consider the impact of the 1990s gender pay gap on these financial outcomes. Throughout the decade, women earned approximately 71 to 77 cents for every dollar earned by men. This statistical reality meant that in the majority of divorce cases, the male spouse was the primary earner. This gap created a massive market for alimony litigation. Lawyers capitalized on this by specializing in permanent alimony cases, which were more common in the 90s than they are today. The goal was to secure a lifetime stream of income for the lower-earning spouse, which in turn justified higher upfront legal fees to win such a high-stakes award. One of the most aggressive historical trends of the 1990s was the war of attrition strategy. This was a calculated method used by wealthier spouses to effectively bankrupt the other side through legal fees before a trial could even begin. A lawyer would file dozens of requests and motions, each requiring a response from the opposing counsel. If the lower-earning spouse could not keep up with the monthly legal bills, they were often forced to settle for a fraction of what they were entitled to. This tactic became so prevalent that by 1999, many states began introducing leveling the playing field statutes. These laws allowed a lower-earning spouse to request that the court order the higher-earning spouse to pay their legal fees in advance, just so the case could proceed fairly. But the biggest shift was not just in how much lawyers were billing, it was in what they were fighting over. As the decade progressed, a new type of evidence began to emerge that would change the industry forever. In the late 90s, the first emails and chat logs began appearing in courtrooms as evidence of infidelity or hidden assets. This changed everything. It was no longer just about bank statements. It was about the secrets hidden in the hard drives of the first home computers. How did the discovery of a single AOL chat log change the outcome of $1 million settlement? And why did the rise of no-fault divorce laws in the 90s actually lead to more litigation instead of less? We are about to look at how the legal industry weaponized the early internet to create a new category of billable evidence that no one in 1990 could have predicted. The transition from physical evidence to digital traces was not a gradual shift. It was a total overhaul of the legal discovery process that began around 1994. Before this, a divorce lawyer would look for a paper trail of physical receipts, telephone logs from the landline, or credit card statements arriving in the mail. But with the mass adoption of personal computers and the launch of America Online, the smoking gun moved from the glove box of a car to the internal hard drive of a family computer. In 1996, the average hard drive size was roughly 1.2 to 2.1 gigabytes. To a modern viewer in 2026, that sounds like a single high-definition photo, but in the mid-90s that was a labyrinth of potential evidence. Imagine you are a legal associate in 1997. Your client, a person we will call Robert, suspects his spouse is hiding assets in an offshore account or is engaging in a clandestine relationship. Instead of just hiring a private investigator to follow a car, you now have to hire a computer forensic specialist. At that time, there were no standardized, user-friendly software suites for legal data recovery. These specialists were often former government intelligence contractors or high-level IT professionals who billed at rates often exceeding $500 per hour. They would physically come to the home, remove the hard drive, and perform a bit-by-bit image of the disk. This process alone could take 12 to 24 hours of billable time. The historical trends show that the cost of electronic discovery in the late 90s added an average of $15,000 to $30,000 to the cost of a contested divorce. This was because lawyers had to manually review thousands of early emails and chat logs. There were no AI-driven filters to categorize relevance. Every single AOL chat log, every early Yahoo email, and every Quicken file had to be printed out and categorized by hand. This created a new revenue stream for law firms: the digital document review fee. A law firm could assign 3 paralegals to spend a week reading through printed chat logs, billing the client for every minute. The irony is that the early internet, which was supposed to make communication easier, actually made the divorce process significantly more expensive and intrusive. This brings us to the great paradox of the 1990s, the impact of no-fault divorce laws. By 1990, nearly every state in the U.S. had adopted some form of no-fault divorce, which allowed a couple to end a marriage without proving grounds like adultery, cruelty, or abandonment. On paper, this was supposed to lower the conflict and the cost. However, historical data suggests the opposite happened. When you remove the need to litigate the cause of the breakup, the legal energy does not simply disappear. It shifts. In the 90s, that energy moved entirely into the realm of financial asset valuation and child custody. Because the grounds for divorce were no longer at issue, lawyers began to focus on the concept of equitable distribution with a new, aggressive intensity. In states like New York and California, the 90s saw a massive increase in the litigation of non-tangible assets. This was the era where a spouse's professional degree, their celebrity status, or even their future book royalties became the primary targets of legal warfare. If a husband worked as a surgeon while the wife supported him through medical school, the lawyer for the wife in 1995 would argue that her contribution was an investment in a marital asset, his future earning capacity. Step by step, a lawyer would build this case by hiring an actuary. Step 1. Calculate the projected earnings of a surgeon over a 30-year career. Step 2. Subtract what the person would have earned with only a standard undergraduate degree. Step 3. Calculate the present value of that multi-million-dollar difference. Step 4. Argue for a 30 to 50% share of that value for the non-degree holding spouse. This specialized litigation meant that a case which might have been a simple filing in 1970 became a 3-year battle involving multiple expert witnesses and hundreds of thousands of dollars in fees. The no-fault system actually gave lawyers more time to focus on the most profitable parts of the case. The numbers. By 1998, we also saw the rise of the specialized custody evaluation. As more mothers worked outside the home and the traditional roles of the 1950s and 60s continued to dissolve, the fight over who got the children became a data-driven enterprise. It wasn't just about who was the better parent, it was about who had the better expert. Lawyers began to regularly employ forensic psychologists to perform multi-month evaluations of the family unit. These evaluations often cost between $5,000 and $20,000. The psychologists would interview the parents, the children, the teachers, and even the neighbors, producing a 100-page report that the lawyers would then spend dozens of billable hours deconstructing in court. Consider the case study of a high-earning couple in 1999, which we can call the Miller case. The Millers were both executives in the burgeoning tech sector of Northern Virginia. Their divorce was not about who cheated. It was about the valuation of their early-stage tech stocks and the custody of their 2 children. The case lasted 3.5 years. During that time, the legal fees consumed nearly 20% of their total net worth. The lawyers involved were not just litigating a breakup. They were managing a complex corporate dissolution. This historical trend highlights how the 90s professionalized family law, to the point where the legal process itself became a significant drain on the very marital estate the parties were fighting over. The statistical data from the American Bar Association during the late 90s reveals a sharp increase in the number of attorneys who identified as specialists. In 1990, only a small fraction of attorneys were board-certified in family law. By 1999, that number had more than tripled in many states. This specialization allowed for higher hourly rates, but it also created an arms race. If one side hired a board-certified specialist, the other side felt they had no choice but to do the same. This drove the average cost of a contested divorce in a major U.S. city from roughly $15,000 in 1990 to over $45,000 by the end of the decade. Furthermore, the 1990s saw the birth of the celebrity divorce lawyer as a household name. This was the decade where attorneys began to brand themselves, using the media to create an aura of invincibility. This branding allowed them to demand massive retainers, often ranging from $25,000 to $50,000 just to take a case. These retainers were not a guarantee of an outcome, but a potential outcome of the high-stakes environment where the lawyer's reputation was as much a part of the fee as their legal work. But as the 90s drew to a close, a new and even more complex financial instrument began to dominate the high-net-worth divorce market. It was something that lawyers in 1990 hadn't even considered: the offshore trust and the sophisticated shell company. As the global economy became more interconnected, wealthy individuals began moving money through jurisdictions like the Cayman Islands or the Isle of Man. How did the divorce lawyers of the late 90s crack these international codes? And how did a single piece of software, released in 1998, change the way every lawyer calculated child support forever? In the next part, we are going deep into the world of international asset tracing and the software revolution that turned the courtroom into a digital battlefield. The digital battlefield of the late 1990s was not fought with high-speed fiber optics, but with the screeching sounds of 56K modems and the slow, methodical extraction of data from local servers. As we moved into the latter half of the decade, the divorce lawyer industry encountered a new type of client: the globalized professional. In 1990, if a husband in Chicago wanted to hide assets, he might put cash in a safe deposit box or buy gold coins. By 1998, that same individual could move $500,000 to a shell company in the British Virgin Islands with a few phone calls and a fax machine. This era marked the birth of the jurisdictional shell game, a historical trend that forced family law firms to evolve into international investigative agencies. To understand the complexity, imagine a case study from 1998 involving a character we will call David, a software executive in San Francisco. David's company was preparing for an IPO, and his marital estate was suddenly worth tens of millions of dollars. His legal team didn't just consist of a divorce lawyer. They hired a network of international counsel. This was the first time in history that the average high-net-worth divorce required an understanding of the Hague Convention on the taking of evidence abroad. If Sarah, David's spouse, wanted to prove he had moved marital funds into a Nevis trust, her lawyers had to navigate a multi-step international legal labyrinth. Step 1 involved the issuance of letters rogatory, a formal request from a U.S. court to a foreign court. Step 2 was the hiring of local counsel in the foreign jurisdiction, which often cost a $10,000 retainer just to open a file. Step 3 was the actual forensic audit of the foreign bank, which could take years. In the context of 2026, we might see this as a slow process, but in the 90s, this was the cutting edge of legal warfare. The potential outcomes of these cases were often decided not by who was right, but by who had the deeper pockets to sustain a multi-jurisdictional fight. While the wealthy were fighting over offshore accounts, the rest of the industry was being rocked by a software revolution that would change the courtroom experience forever. Before 1995, if a judge needed to calculate child support or alimony, they often relied on clunky, printed guideline tables or simple calculators. Then came the rise of specialized legal software like DissoMaster and FinPlan. These programs, designed to run on Windows 95 and later Windows 98, promised to bring objective mathematics to the emotional chaos of divorce. The impact of this software cannot be overstated. It shifted the lawyer's role from a negotiator to a data entry specialist. The historical trend shows that once these programs became the industry standard, the battle moved from the final number to the input data. Lawyers would spend hours arguing over whether a specific tax deduction or a health insurance premium should be checked in a specific box within the software. Statistical data from California and New York during the late 90s suggests that the use of these programs actually increased the amount of time spent on financial discovery. Why? Because the software was so precise that even a small error in the input could result in a $1,000 a month difference in support payments. Consider the granularity of this process. Step 1. The lawyer gathers every pay stub and tax return. Step 2. They input variables like the number of days the child spends with each parent, a calculation known as timeshare. Step 3. The software runs a complex algorithm based on the current year's tax codes. Step 4. The lawyer generates a report that looks incredibly official and difficult to challenge. This created a new psychological dynamic in the courtroom. Judges, often overwhelmed by high caseloads, began to treat these computer-generated reports as gospel. This forced every lawyer in the industry to purchase the software, which cost hundreds of dollars per seat plus annual update fees, creating yet another revenue stream for the legal tech sector. This period also saw the implementation of the Personal Responsibility and Work Opportunity Reconciliation Act of 1996, also known as the Welfare Reform Act. This was a massive shift in how the U.S. government viewed child support. It mandated that all states implement automated systems for tracking child support payments and created the National Directory of New Hires. For the divorce lawyer industry, this meant that child support enforcement became a streamlined, government-backed operation. Lawyers were no longer just chasing individual parents, they were navigating a massive federal database. This historical trend professionalized the collection of support, turning it into a data-driven enterprise that generated millions in legal fees as parents fought to adjust their obligations in the face of increasingly efficient enforcement. Furthermore, we saw the rise of the Qualified Domestic Relations Order, or QDRO, specialist. As the 401k became the primary retirement vehicle for the American middle class in the 90s, the legal process of splitting these accounts became a nightmare of IRS regulations. A standard divorce lawyer often didn't have the expertise to draft these orders without triggering massive tax penalties for their clients. Thus, the industry birthed a subspecialty. By 1997, it was common for a divorce lawyer to outsource the drafting of a QDRO to a specialist who charged a flat fee of $500 to $1,000 per order. This was a classic example of the industry's fragmentation and professionalization. A single divorce was no longer the work of one person, but a coordinated effort of multiple specialists, each taking a piece of the marital estate. The statistics of this era are telling. By 1999, the average cost of a divorce in the United States had reached approximately $15,000 to $20,000 when factoring in all these specialized services. But the revenue wasn't just coming from the fees, it was coming from the volume. The late 90s saw a spike in what sociologists called the gray divorce, couples ending long-term marriages after their children left the home. These cases were particularly lucrative for lawyers because they involved the maximum amount of accumulated assets, from decades-old pensions to fully equity-rich real estate. In this environment, the marketing of divorce services reached a fever pitch. This was the decade where the Yellow Pages, the primary search engine of the 90s, became dominated by full-page, full-color ads for divorce attorneys. Firms began using high-stakes language in their advertising, focusing on protection and dominance. They weren't just offering a service, They were offering a shield against the complex, data-driven system they had helped build. This shift in branding moved the industry away from the image of a counselor and toward the image of a tactical operative. But there was a darker side to this professionalization. As the industry became more focused on the math and the software, something human was lost. The 90s saw the emergence of the silver bullet tactic, a specific legal maneuver designed to end a case instantly by attacking the other side's credibility or financial standing through a single, devastating motion. One of these tactics involved the weaponization of temporary restraining orders to gain immediate, exclusive access to the family home and the children. How did this aggressive maneuver become a standard part of the 90s legal playbook? And what were the statistical consequences for the families involved? In the next part, we are going to look at the rise of tactical litigation and the controversial methods that defined the peak of the 90s divorce machine. The tactical landscape of the mid to late 1990s saw the emergence of a strategy that many legal historians now refer to as the silver bullet. This maneuver was not about a final settlement or a long-term parenting plan. It was about seizing immediate control of the marital environment. In the 1990s, the legal standard for obtaining a temporary restraining order, or TRO, shifted as states sought to address rising concerns about domestic safety. While these legal protections were vital for victims, the divorce lawyer industry quickly identified how these emergency orders could be used to gain a massive tactical advantage in a contested divorce. Imagine it is 1996. A couple we will call James and Jennifer are beginning a high-conflict divorce in a suburb of Chicago. James is a partner at an accounting firm, and Jennifer has been the primary caregiver for their two children. Jennifer's attorney advises her that if they file for a standard divorce, James could remain in the family home for months or even years while the case wins through the system. However, by filing an ex parte motion for a temporary protective order, the legal team can essentially remove James from the home within 24 hours without him ever being present in the courtroom to defend himself. The statistics from this era are striking. In several major U.S. metropolitan areas, the number of emergency ex parte orders filed concurrently with a divorce petition rose by nearly 35% between 1992 and 1998. This was not always a reflection of an increase in physical danger, but rather a historical trend toward what lawyers called aggressive positioning. Once a spouse was removed from the home, they lost immediate access to their children, their personal documents, and their sense of stability. This created a psychological state of desperation, often forcing the removed spouse to agree to unfavorable financial terms just to see their children again. For the lawyer, this maneuver generated thousands of dollars in billable hours for the initial filing, the emergency hearing, and the subsequent litigation to either uphold or vacate the order. The procedural steps for this tactical litigation were highly standardized by 1997. Step 1. The lawyer drafts an affidavit focusing on allegations of emotional or physical distress. Step 2. The lawyer appears before a judge in a non-adversarial hearing, meaning the other side is not notified. Step 3. The judge, operating on a better safe than sorry principle, grants the temporary order. Step 4. The sheriff serves the order, removing the other party from the residence. Step 5. A follow-up hearing is scheduled 14 to 21 days later. During those 3 weeks, the lawyer who filed the order has total control over the flow of information and the marital assets located within the home. This strategy led to a secondary industry within family law, the domestic violence defense specialist. Because a restraining order could impact a person's professional license or their ability to own a firearm, the stakes were incredibly high. Statistical data from the late 90s shows that lawyers who specialized in defending against these tactical orders could charge a premium, with retainers for emergency defense work reaching $10,000 for just the first 2 weeks of representation. The legal industry was effectively profiting from both the offensive use of these orders and the defensive response. At the same time, we saw the rise of parental alienation syndrome, or PAS, as a dominant legal theory. Although highly controversial in the medical community, PAS became a staple of 1990s custody battles. Lawyers would hire psychological experts to testify that one parent was systematically brainwashing the child against the other parent. The cost of this litigation was astronomical. A PAS defense or prosecution required multiple expert witnesses, each billing $400 an hour, and hundreds of pages of psychological evaluations. By 1998, PAS was cited in an estimated 15% of contested custody cases across the United States. This was a direct result of the industry's shift toward high-conflict, expert-driven litigation. The financial fallout of these tactics changed the way the American middle class viewed divorce. Before the 1990s, a middle-class divorce was often seen as a painful but manageable financial event. By 1999, a high-conflict divorce involving these tactical maneuvers could easily cost a family their entire home equity. Historical trends indicate that the average duration of a contested divorce increased from 12 months in 1990 to 18 months by 1999, largely due to the increase in procedural motions and the use of expert witnesses. While the litigation machine was accelerating, a counter-movement was gaining traction: alternative dispute resolution, or ADR. By the mid-90s, the sheer cost of the court-based system became so prohibitive that the market began to demand a different way. This led to the rise of the professional mediator. Mediation in the 1990s was a burgeoning field that promised a potential outcome of a faster, cheaper resolution. However, the legal industry did not simply step aside. Instead, it co-opted the mediation process. Step by step, the industry transformed mediation from a collaborative process into a lawyer-dominated one. In 1990, mediation might have involved a couple sitting with a counselor. By 1997, it was common to have four-way mediation: two spouses, two lawyers, and a mediator who was often a retired judge. This meant that while the couple was avoiding a trial, they were still paying for three high-priced professionals to be in the room simultaneously. The statistical shift here is fascinating. The number of cases settled in mediation grew by over 50% in the 90s, yet the total revenue of the family law industry continued to rise. Lawyers found that they could bill just as much for 20 hours of mediation preparation and attendance as they could for 5 hours in a courtroom. Furthermore, the 1990s saw the birth of collaborative divorce, a model where both parties and their lawyers sign a contract agreeing not to go to court. If the process fails, the lawyers must resign, and the parties have to start over with new counsel. While intended to reduce conflict, this model created its own unique billing structures, often involving teams of financial neutrals and child specialists. By 1999, the business of collaborative law had become a distinct brand within the industry, catering to wealthy clients who wanted to avoid the public spectacle of the courtroom, but were still willing to pay top-tier professional fees. As we look back from 2026, the legacy of these 1990s tactics is clear. The industry moved away from being a simple service provider and became a strategic partner in the dissolution of the American family unit. The decade ended with the industry more powerful, more specialized, and more expensive than ever before. But as the year 2000 approached, a new variable was about to enter the equation, one that would make the paper-heavy discovery of the 90s look like a relic of the Stone Age. The dot-com bubble was about to burst, and with it, the valuation of marital assets would go into a tailspin. How did divorce lawyers handle the sudden disappearance of millions of dollars in paper wealth? And how did the rise of the first social media platforms in the very late 90s provide a new, terrifyingly efficient way to monitor a spouse's every move? In the next part, we are going to look at the financial crash of the late 90s and the birth of digital surveillance in the divorce industry, a trend that would set the stage for the total transparency and total conflict of the modern era. The year 1999 represented a precarious peak for both the American economy and the divorce lawyer industry. As the NASDAQ Composite surged toward its eventual high of over 5,000 points, the paper wealth of millions of American households reached levels that were historically unprecedented. For the divorce industry, this was a season of high-stakes asset valuation that required a level of mathematical precision and market foresight never before seen in family court. However, the impending burst of the dot-com bubble created a unique legal crisis. How do you divide a marital estate that is losing 30% of its value every month during the litigation process? This period saw the birth of the volatility defense, a strategy where lawyers argued for specific valuation dates to either protect or capture wealth that was essentially evaporating in real time. Imagine if you are a software architect named Michael living in 1999 Austin, Texas. Michael was an early employee at a tech startup, and his stock options on paper were valued at $8 million. When his wife, Linda, filed for divorce in mid-1999, the legal teams immediately began a battle over these options. In the historical context of 1999, these were not just numbers, they were the primary fuel for the divorce machine. Michael's lawyers argued that the options were unvested and should be valued at their strike price, while Linda's lawyers hired specialized valuation experts to argue that the Black-Scholes model, a complex mathematical formula used to price options, should be used to project their future multi-million-dollar worth. The step-by-step breakdown of this valuation battle looked like this. Step 1. The discovery of the grant agreements and vesting schedules. Step 2. The hiring of a CVA, or Certified Valuation Analyst, who billed at $400 an hour to run hundreds of market simulations. Step 3. The filing of a motion to determine the date of valuation. In most states during the 90s, the law allowed for the valuation date to be either the date of separation or the date of the trial. If the trial date was set for late 2000, after the bubble began to burst, the marital estate that was once worth $8 million might have plummeted to $800,000. This created a frantic rush among divorce lawyers to either accelerate or delay trials, based on which way the market was moving. Statistical trends from 1999 to 2001 show a dramatic spike in malpractice claims against divorce lawyers who failed to account for this market volatility, highlighting the extreme risks inherent in high-net-worth litigation during an economic collapse. As the financial landscape shifted, so did the methods of gathering evidence. The late 90s saw the first widespread commercial availability of spyware. In 1998, a company called SpectreSoft released one of the first consumer-grade keystroke loggers. This software allowed a suspicious spouse to record every single letter typed on a computer, every website visited, and every chat message sent. For the divorce lawyer industry, this was a Pandora's box. Suddenly, evidence that used to take months of private investigation to uncover was being handed to attorneys on a silver platter, or rather a floppy disk. However, this created a massive legal gray area regarding the 1968 Wiretap Act and the Electronic Communications Privacy Act of 1986. Lawyers in 1999 were forced to become experts in federal privacy law almost overnight. If an attorney used evidence that was gathered through a keystroke logger installed on a spouse's computer, were they committing a federal felony? The potential outcomes of these cases often hinged on whether the computer was considered marital property and whether there was an expectation of privacy. Case studies from 1999 reveal a surge in motions to suppress electronic evidence, with lawyers billing thousands of dollars to argue over the technical definition of intercepting a communication versus accessing stored data. Step by step, the industry integrated digital surveillance into the standard litigation playbook. Step 1. The client provides a disk of logged chats or emails. Step 2. The lawyer performs a risk-benefit analysis to see if the evidence is admissible. Step 3. If admissible, the lawyer uses the data to force a settlement by threatening to make the private logs a matter of public court record. This tactic, while aggressive, was incredibly effective in the late 90s before courts had established firm rules on digital privacy. It turned the divorce process into a form of digital blackmail, where the one who controlled the hard drive controlled the outcome. The statistical growth of forensic information technology within law firms during this time was explosive. By 1999, nearly every major family law firm in cities like New York, Los Angeles, and Chicago had either an in-house IT specialist or a preferred vendor for data recovery. The cost of a basic hard drive scrub and analysis moved from an occasional expense to a standard line item in a divorce budget, typically ranging from $3,000 to $7,000. This was the era where the term e-discovery began to move from corporate litigation into the world of domestic relations. We must also consider the role of early social networking. While sites like Classmates.com and early incarnations of 6degrees.com seem primitive in 2026, in 1998 and 1999, they were providing a new way for lawyers to prove lifestyle discrepancies. If a spouse claimed they had no money for child support, but were posting about a luxury vacation on a public message board or an early social site, that information was gold. Lawyers began assigning paralegals to perform what they called digital stakeouts, spending hours searching the burgeoning internet for any trace of a spouse's activities. This was the beginning of the end of privacy in the divorce process. Beyond the tech, the 1990s also saw a shift in the tax implications of divorce settlements, particularly with the rise of the Roth IRA, which was introduced in 1997. Divorce lawyers in the late 90s had to become savvy in comparing the long-term value of a traditional IRA versus a Roth IRA when dividing assets. Because Roth IRAs are funded with after-tax dollars and traditional IRAs are not, a dollar-for-dollar split was no longer equitable. Lawyers had to perform complex tax-affecting calculations to ensure their clients weren't getting the short end of the stick. This added yet another layer of billable expertise to the process, as firms brought in tax attorneys to consult on what used to be simple retirement account splits. As we moved toward the new millennium, the industry was no longer just about who got the house or the kids. It was about managing a complex portfolio of digital data, volatile stocks, and intricate tax vehicles. The divorce lawyer of 1999 was a far more dangerous and sophisticated professional than the lawyer of 1990. They had access to more data, more expert witnesses, and more aggressive tactical maneuvers than ever before. But as the clock ticked toward Y2K, a new trend was emerging that would take the industry in an even more specialized direction. The rise of the prenuptial agreement as a standard requirement for the middle class, not just the wealthy. How did the 1990s turn the prenuptial agreement from a taboo subject into a multi-billion-dollar sub-industry? And why did the surge in second and third marriages during this decade create a massive new market for postnuptial litigation? In the next part, we are going to look at the rise of the contract-based marriage and how lawyers began to litigate the very agreements they had drafted years earlier, creating a cycle of revenue that ensured the divorce machine would never stop turning. By the beginning of 1990, the prenuptial agreement was still largely viewed by the American public as a tool for the ultra-wealthy or the Hollywood elite. However, as the decade progressed, a massive shift occurred in the business model of family law. Lawyers realized that the most profitable way to manage a client's life cycle was not just to wait for the marriage to fail, but to draft the roadmap for its potential dissolution before the first toast was even made. This led to the normalization of the contract-based marriage. In 1990, an estimated 5% of marrying couples used prenups. By 1999, that number had tripled among the upper middle class, particularly in high-growth regions like the Sun Belt and the Silicon Valley. To understand the mechanics of this, imagine a scenario in 1994 involving a professional we will call Kevin. Kevin was a 42-year-old mid-level executive at a growing pharmaceutical company in New Jersey. This was his second marriage. He had seen his first marriage end in 1988, a process that cost him half of his pension and a significant portion of his home equity. When he met his second wife, a successful marketing consultant, his lawyer suggested a premarital agreement. In the 1990s, the fee for drafting such an agreement was relatively modest, often ranging from $1,000 to $3,000. But for the legal industry, this was a strategic investment. These documents were essentially insurance policies for future litigation. The 1990s saw the widespread adoption of the Uniform Premarital Agreement Act, or UPAA, across over 25 U.S. states. This act provided a clear statutory framework for what a prenup could and could not do. While it was intended to create certainty, it actually provided a new set of rules for lawyers to litigate. In 1995, a lawyer's job was to ensure the agreement met three specific criteria. It had to be in writing, it had to be signed voluntarily, and there had to be full and fair disclosure of all financial assets. If any of these pillars were weak, the agreement could be challenged years later. This created a lucrative subspecialty, the prenup challenge. Step by step, the industry developed a protocol for attacking these 1990s agreements. Step 1. The lawyer would look at the timing of the signing. If the agreement was signed 48 hours before the wedding, the lawyer would argue the spouse signed under duress. Step 2. The lawyer would perform a forensic audit of the 1990s financial disclosures. If Kevin had failed to mention a small brokerage account or an inheritance he expected to receive in 1996, the entire agreement could be ruled unconscionable and tossed out by a judge. Step 3. The lawyer would look for a change in circumstances that made the original agreement fundamentally unfair by 1999 standards. This created a cycle of revenue. A lawyer would bill $3,000 to draft the agreement in 1992, and then should the marriage fail in 1998, they or another firm would bill $50,000 to either defend or overturn that same document. The statistical trend was clear. As the volume of prenups grew, the volume of high-stakes litigation surrounding their validity grew at an even faster rate. The document that was supposed to prevent a court battle often became the very reason for a 3-year legal war. We must also look at the rise of the sunset clause, a popular 1990s legal feature. A sunset clause stated that the prenuptial agreement would automatically expire after a certain number of years, often 10 or 15. Lawyers marketed these clauses as a way to make the idea of a prenup more palatable to a hesitant spouse. Imagine if Kevin told his future wife that the agreement only protected his assets for the first 10 years of marriage as a safety net. Sounded reasonable. However, for the legal industry, the sunset clause was a ticking time bomb. As many of these agreements reached their expiration dates toward the end of the 1990s, it triggered a wave of strategic divorce filings. If a marriage was failing in year 9, The wealthier spouse's lawyer might advise filing for divorce immediately to ensure the prenuptial protections were still in force before the sunset clause kicked in. The 1990s also birthed the postnuptial agreement as a mainstream legal product. This was a contract signed after the couple was already married, often used as a condition for reconciliation after a period of separation or infidelity. In 1997, the historical trends show a significant increase in these agreements among couples who had seen their net worth skyrocket during the mid-90s bull market. These documents were notoriously difficult to enforce because, unlike a prenup, the parties already had a legal duty to support one another. This ambiguity was a goldmine for lawyers. A single postnuptial agreement could involve months of negotiation between two sets of attorneys, each billing $300 an hour, to create a document that might not even hold up in court if challenged. Furthermore, the industry saw a rise in blended family litigation. By the mid-90s, nearly 40% of all marriages in the U.S. were a second or third marriage for at least one partner. This demographic shift created complex inheritance and support issues that required specialized legal intervention. Lawyers began to regularly draft interspousal contracts that dictated how much of a marital estate would go to children from a previous marriage versus children of the current marriage. This wasn't just divorce law. It was a hybrid of family law, contract law, and estate planning. From the perspective of 2026, we can see that the 1990s were the laboratory where the modern hyper-contractualized version of American marriage was perfected. The legal industry shifted the cultural narrative from marriage as a social institution to marriage as a partnership of assets. This professionalization of the relationship itself meant that every milestone, buying a home, receiving a promotion, or having a child, became a potential trigger for a legal update or a revised agreement. The lawyer became a permanent, silent partner in the American household. By 1999, the divorce lawyer industry had reached a level of administrative and tactical maturity that made it nearly immune to economic downturns. Even as the dot-com bubble began to show cracks, the industry was prepared. If assets were going up, people fought over the gain. If assets were going down, they fought over the losses. The machine was self-sustaining. But as the decade drew to a close, a new and highly emotional front opened up in the legal wars. It was no longer just about the money or the house. It was about a new phenomenon that the 1990s economy made possible: the long-distance, high-conflict relocation battle. With the rise of the globalized workforce in the late 90s, more parents wanted to move across the country for new job opportunities after a divorce. This created a legal crisis that the 1990s courts were completely unprepared for. How did the industry turn a parent's career move into one of the most expensive and protracted legal battles of the decade? And why did the emergence of the first handheld cell phones in 1998 provide a new 24-hour surveillance tool that lawyers use to track parenting time to the minute? In the next part, we are going deep into the world of relocation litigation and the birth of the mobile digital custody war. The relocation battle of the late 1990s represents one of the most significant and expensive shifts in the historical trends of American family law. Before this decade, the American population was relatively stationary compared to the hypermobile workforce of today. However, as the 1990s progressed, the rise of the globalized executive and the dot-com boom required employees to be willing to move across the country or the world at a moment's notice. This geographic instability collided head-on with the legal structures of child custody. By 1996, the divorce lawyer industry had identified a new, incredibly lucrative frontier: the move-away case. Imagine you are a marketing director named Christopher in 1997, living in a suburb of Atlanta. You have been divorced for 3 years and share joint custody of your 2 children with your ex-spouse, Karen. Suddenly, Karen receives a career-defining job offer in San Francisco. In the 1980s, Karen might have been discouraged from moving by the prevailing legal hurdles. But by 1997, the legal landscape was shifting. If she moves, your relationship with your children changes from weekend visits to bi-monthly flights. For a divorce lawyer, this scenario is a high-stakes binary conflict. There is no middle ground in a relocation case. Either the child moves or they stay. This winner-take-all dynamic allowed firms to charge massive premiums because the emotional stakes were the highest the industry had ever seen. The historical trend was codified by landmark decisions like the 1996 California Supreme Court case in Remarriage of Burgess. This case fundamentally changed the rules of the game by stating that a custodial parent seeking to relocate does not have an affirmative burden to prove that the move is necessary. Instead, the move was presumed to be in the child's best interest unless the non-custodial parent could prove it would be detrimental. This shift in the burden of proof sent shockwaves through the industry. Suddenly, thousands of non-custodial parents across the United States were forced to hire legal teams to perform an exhaustive, multi-step defense against relocation. Step 1 in a 1997 relocation defense involved the hiring of a relocation expert. This was a specialized subcategory of child psychologist who charged between $3,000 and $7,000 to evaluate the impact of a cross-country move on a child's psyche. Step 2 involved the vocational expert, who would testify about whether similar job opportunities existed for the moving parent in their current city, effectively trying to prove the move was a choice rather than a necessity. Step 3 was the school district comparison. Lawyers would bill dozens of hours to gather statistical data on standardized test scores, extracurricular activities, and crime rates in the new city versus the old one. By the time a relocation case reached a trial in 1998, the combined legal fees for both sides often exceeded $100,000. This era also saw the implementation of the 1997 Uniform Child Custody Jurisdiction and Enforcement Act, or UCCJEA. This was a massive piece of legislation designed to prevent a phenomenon known as forum shopping. Before the UCCJ, a parent might take a child to a different state and try to get a more favorable custody order from a local judge who didn't know the case history. The 1990s legal industry had to master this complex new statute to ensure that cases remained in the home state. For the divorce lawyer, the UCCJ was a double-edged sword. It provided more clarity but also required more specialized knowledge, which in turn justified the rising billable rates that reached an average of $350 per hour in major U.S. hubs by 1999. While the lawyers were arguing over jurisdictions, the tools of the trade were becoming increasingly digital and intrusive. Enter the era of the digital leash. In 1998, the Nokia 5110 and the Motorola StarTAC became ubiquitous. While these devices were marketed as tools of convenience, the divorce lawyer industry quickly weaponized them. Lawyers began advising their clients to keep meticulous logs of every single cell phone call or page sent to the other parent. Imagine if every time you were 5 minutes late for a 1999 custody exchange, your ex-spouse logged it on their handheld Palm Pilot. This data was then synced to a desktop computer and printed out as a 50-page exhibit for the next court hearing. This historical trend moved the industry away from anecdotal evidence toward a model of constant, digital surveillance. The cost of analyzing these phone records became a new billable event. A paralegal might spend 10 hours cross-referencing a cell phone bill with a printed visitation calendar to find discrepancies. This granularity allowed lawyers to argue over minutes of parenting time, further inflating the cost of litigation. The statistical reality of the late 90s was that the divorce industry was becoming a consumer of technology. Law firms began investing in high-end scanners and early database software to manage the sheer volume of digital and physical evidence being produced by cell phones, pagers, and early internet activity. By 1999, the average contested custody case involved 3 times as many physical exhibits as it did in 1990. This was the birth of the paperless office that wasn't actually paperless. It just meant that every digital record was printed 10 times for various court filings. Beyond the technology, we must look at the rise of the guardian ad litem, or GAL. In the 1990s, courts increasingly appointed these independent attorneys to represent the best interests of the children. While the concept was noble, the financial reality was often crushing for the parents. In many jurisdictions, the parents were required to split the hourly fee of the GAL, which was often the same as a high-end private attorney. By 1998, a family might be paying for 3 separate lawyers. One for the husband, one for the wife, and one for the children. This tripled the legal drain on the marital estate, leading to potential outcomes where the family's college savings or retirement funds were entirely consumed by the very process meant to protect the children's future. As we look at the data from the end of the decade, a clear pattern emerges. The 1990s divorce lawyer was no longer just a legal representative. They were the manager of a multidisciplinary team of psychologists, technologists, and state-appointed advocates. The industry had successfully moved from the courtroom to the everyday lives of the American public through the use of mobile technology and specialized statutes. The legal process had become a permanent fixture of the post-divorce experience. But as the world turned its attention to the Y2K bug and the dawn of the new millennium, the divorce lawyer industry was preparing for its most significant transformation yet. The late 90s saw the very first experiments in unbundled legal services and the rise of the internet-based legal document. How did the industry react when the first websites began offering $50 divorce kits, threatening the high-margin billable hour model? And how did the 1999 obsession with privacy lead to the creation of the most restrictive and expensive confidentiality agreements in history? In the next part, we are going to look at the industry's war against DIY legal services and the rise of the ironclad non-disclosure agreement that turned private divorces into state-sanctioned secrets. As the clock ticked toward the new millennium, the divorce lawyer industry faced a challenge that was perhaps more threatening than any courtroom adversary: the democratization of legal information via the early internet. By 1998, approximately 26% of American households had internet access, a number that nearly doubled by the end of 1999. For decades, the family law industry had operated on a model of information asymmetry. The lawyer held the keys to the statutes, the forms, and the procedural knowledge. But suddenly, websites began popping up offering $50 divorce kits and automated form-filling software. This was the dawn of the DIY legal movement, and the response from the legal establishment was nothing short of a full-scale institutional war. To understand the intensity of this conflict, we have to look at the historical trends of unauthorized practice of law, or UPL investigations. In 1999, the Texas Unauthorized Practice of Law Committee launched a high-profile investigation into Nalo Press, a publisher of self-help legal books and software. The committee argued that by providing software that helped people fill out legal forms, Nalo was effectively practicing law without a license. This was a pivotal moment. The legal industry was not just fighting for its revenue, it was fighting to maintain its status as the sole gatekeeper of the American justice system. Statistical data from this period shows that between 1997 and 1999, UPL complaints against non-lawyer software providers increased by over 40% in several key jurisdictions. Imagine if you were a mid-level manager named Brandon in 1999, living in Dallas. Brandon and his spouse had reached an amicable agreement and wanted to avoid the $15,000 price tag of a traditional contested divorce. Brandon went to a local computer store, bought a legal software package for $49, and prepared his own filing. From a 2026 perspective, this seems like common sense. But in 1999, the legal industry viewed Brandon not as an empowered consumer, but as a risk to the system. Lawyers argued that DIY kits would lead to a potential outcome of clogged court dockets and legally flawed decrees that would require even more expensive litigation to fix later. This was the primary marketing defense of the billable hour: the idea that a cheap divorce today would lead to an expensive disaster tomorrow. Step by step, the industry moved to neutralize the DIY threat. Step 1. State bar associations issued public service announcements warning about the dangers of self-representation. Step 2. Judges in many jurisdictions began requiring increasingly complex local forms that the national software kits had not yet updated. Step 3. Lawyers shifted their business model. They realized that if they could not stop the DIY movement, they would have to co-opt it. This led to the birth of unbundled legal services, also known as limited scope representation. In this unbundled model, a lawyer wouldn't handle the whole case. Instead, they would charge a flat fee, perhaps $500 to $1,000, just to review the paperwork the client had prepared themselves. This allowed the industry to capture the DIY market while still maintaining their role as the final authority. By 1999, approximately 15% of family law firms had begun offering some form of unbundled services, creating a new, high-volume, low-touch revenue stream that supplemented their high-stakes litigation practice. While the battle for the middle-class DIY market was raging, the top tier of the divorce lawyer industry was moving in the opposite direction, toward total ironclad secrecy. As the dot-com era created a new class of young, ultra-wealthy individuals, the demand for privacy reached an all-time high. In the 1990s, divorce records were, and still are in many states, matters of public record. For a CEO of a publicly traded company in 1998, the public disclosure of a divorce settlement could affect stock prices or reveal sensitive corporate information hidden in marital assets. This gave rise to the Industrial Strength Non-Disclosure Agreement, or NDA, within the divorce process. Lawyers began drafting agreements that were far more complex than simple confidentiality clauses. These 1999-era NDAs included liquidated damages provisions, clauses stating that if one spouse leaked the details of the settlement to the press, they would automatically owe the other spouse a massive sum, sometimes reaching into the millions. The process of creating these state-sanctioned secrets followed a specific 1990s protocol. Step 1. the lawyers would move for a protective order to seal the financial disclosures, arguing that public access would cause irreparable commercial harm. Step 2. They would hire private referees or retired judges to conduct the hearings in private office buildings, rather than public courtrooms. Step 3. The final settlement would be filed as a confidential document, with only the bare minimum of information available to the public. Historical trends show that the use of private judging in states like California surged by over 60% in the late 90s. This essentially created a two-tiered justice system: a public, messy, and increasingly DIY system for the masses, and a private, expensive, and perfectly curated system for the elite. Consider a case study of a tech founder in 1999. His legal team spent over 200 billable hours just negotiating the terms of the confidentiality agreement, before they even discussed the division of assets. They had to account for everything from traditional media leaks to the emerging threat of early internet message boards. The lawyer's role had shifted from being a litigator to being a brand protector. The fee for this specialized privacy work was often a flat premium added on top of the hourly rate, sometimes referred to as a complexity kicker. The statistics of this era reveal a fascinating divergence. While the average cost of a standard divorce was being pressured downward by DIY tools, the cost of a high-end private divorce was skyrocketing. By 1999, a top-tier divorce lawyer in a city like Manhattan could easily command a $100,000 initial retainer for a high-profile client. The industry had successfully segmented itself. It was no longer a monolith. It was a bifurcated market that catered to two entirely different versions of the American dream. However, as the decade came to a close, a new and unexpected variable began to haunt the industry: the long-term impact of the 1990s litigious culture on the lawyers themselves. The high-conflict, high-stakes environment of the 90s had created a burnout crisis within the profession. Statistical surveys from the late 90s showed that family law practitioners had some of the highest rates of career dissatisfaction and stress-related health issues in the entire legal field. This led to a final 1990s trend: the professionalization of the lawyer's own well-being, which ironically became another cost passed on to the client through increased firm overhead and higher administrative fees. As we stand at the threshold of the year 2000 in our journey, we see an industry that has been completely transformed. It survived the rise of no-fault laws, weaponized the early internet, internationalized its reach, and successfully fought off the first wave of automation. But there is one final piece of the 1990s puzzle we haven't touched on yet. It's the statistical legacy of the decade, the numbers that show exactly where all that money went and who really won the legal wars of the 90s. How did the industry's obsession with winning in the 90s set the stage for the massive legislative reforms of the early 2000s? And what is the one statistic from 1999 that predicted the total collapse of the traditional divorce model we see today? In the 10th and final part of this masterclass, we are going to look at the ultimate balance sheet of the 1990s divorce industry, and the final shocking revelation that changed the business of law forever. The final balance sheet of the 1990s divorce lawyer industry serves as a sobering testament to how a profession can successfully industrialize human conflict. By December 31, 1999, the total annual revenue for family law firms in the United States had crossed the estimated $12 billion mark. To put that in perspective, this was an industry that had grown at a rate far exceeding the general inflation of the decade. While the divorce rate itself had actually begun to plateau or even slightly decline by the late 90s, the revenue per case had skyrocketed. This was the ultimate victory of the billable hour over the simplified no-fault ideal. The legal industry had effectively decoupled its profitability from the volume of divorces, and instead tied it to the complexity and duration of the litigation. To understand the wealth extraction ratio of this era, imagine a 1999 case study involving a couple we will call Alex and Jessica. They were a quintessential upper-middle-class American success story, living in a suburb of Seattle. Alex was a project manager for a major aerospace company, and Jessica was a high-level educational consultant. Their combined marital estate, including home equity for 401(k) accounts and a small stock portfolio, was valued at approximately $600,000. In a world with a streamlined legal process, they might have spent $5,000 to divide those assets. However, in the hyper-litigious climate of 1999, their divorce lasted 22 months. The step-by-step financial drain on Alex and Jessica's estate provides a perfect snapshot of the industry's final balance sheet for the decade. Step 1. The initial retainers for two high-end firms totaled $15,000. Step 2. 12 months of discovery. including subpoenas for digital records and 2 depositions, cost an additional $40,000 in billable time. Step 3. The use of a forensic accountant to value Jessica's consulting business added $10,000. Step 4. A 3-day trial, including preparation and expert testimony, cost another $50,000. By the time the final decree was signed in early 2000, the total cost for both sides was $115,000. This meant that nearly 20% of their total life savings had been transferred from the family unit to the legal profession. This is the Pyrrhic victory of the 90s. The parties were legally divorced, but the financial foundation they were fighting to preserve had been significantly hollowed out by the process itself. The historical trends of 1999 also reveal a shocking statistic that would define the industry for the next quarter century: the rise of gray divorce among the baby boomer generation. While younger couples were starting to find ways to avoid the courtroom, couples who had been married for 20 or 30 years were entering the system with the maximum amount of accumulated assets. For a divorce lawyer in 1999, one gray divorce was worth 5 standard divorces. These cases involved the most complex pension valuations, the largest real estate holdings, and the highest stakes for alimony. This demographic shift allowed the industry to maintain record-breaking revenues, even as younger Americans became more skeptical of traditional litigation. However, the excesses of the 1990s triggered a massive legislative and cultural backlash as we entered the 2000s. The industry's obsession with winning at all costs had become a public relations nightmare. By 1999, the state bars and legislatures began a step-by-step process of forced de-escalation. Step 1 was the expansion of presumptive joint custody. Throughout the 90s, custody was treated as a prize to be won, which drove endless litigation. By moving toward a 50-50 starting point, legislatures aimed to cut the legs out from under the custody for leverage strategy. Step 2 was the mandate for mediation. In many U.S. counties by the late 90s, you could not even get a court date until you proved you had attempted to settle in good faith. Step 3 was the introduction of the Collaborative Law Participation Agreement, which explicitly prohibited lawyers from going to court, essentially creating a financial penalty for litigation. As we look back from the year 2026, we can see that the 1990s were the high-water mark for the traditional adversarial divorce machine. The lawyers of that decade perfected a system of manual, paper-intensive, and expert-driven warfare that maximized the billable hour. But in doing so, they created the very conditions that would lead to their own disruption. The high costs of 1999 paved the way for the AI-driven, flat-fee, and algorithm-based platforms we see in 2026. The modern era of legal tech was born from the frustration of the American public, who watched their parents' estates disappear into the pockets of the 1990s legal industrial complex. The legacy of the 1990s is visible in the way we handle domestic law today. The sophisticated asset tracing, the focus on digital evidence, and the professionalization of custody evaluations all have their roots in this pivotal decade. But perhaps the most enduring lesson is the realization that the legal system is not just a neutral referee. It is a business with its own incentives and momentum. The potential outcomes for any family entering the system are still heavily influenced by the structures built during the 90s tech boom and the rise of specialized family law boutiques. The final revelation of the 1990s is that while the lawyers became incredibly wealthy, the legal system itself became nearly inaccessible to the average citizen. By 1999, the industry had priced itself out of the market for the bottom 60% of the population. This created a justice gap that remains one of the most significant challenges in the American legal system today. The professionalization of the industry was a double-edged sword. It provided high-quality, expert-driven results for those who could afford it, but it left millions of others to navigate a complex, data-driven system on their own. In the end, the 1990s divorce lawyer industry was a reflection of the decade itself. Aggressive, booming, tech-obsessed, and increasingly expensive. It was a time when the American household became a corporate entity to be dissolved, and the courtroom became a high-stakes boardroom. As we conclude this masterclass on the statistical overview of this era, we have to ask ourselves, has the industry truly changed, or have the tactics just become more subtle? And what happens when the next generation of 2026 lawyers begins to apply the lessons of the 90s to the world of virtual assets and decentralized finance? The story of the 1990s was just the beginning. The systems built during those 10 years of high-stakes litigation are currently being tested by a new era of digital assets that even the most advanced 1999 forensic accountant couldn't have imagined. How are the children of the 90s divorce boom now using their own experiences to rewrite the laws of the future? And what is the hidden cost of the 1990s legal legacy that we are still paying today in our modern courtrooms? We have explored the math, the tactics, and the money. Now it is time to look at the next frontier of legal dissolution in our upcoming series on the rise of the algorithmic divorce.